Hi there. So I want to continue our Fourth Amendment discussion. We've already talked about what is a search or what's not a search, and what is constitutionally protected or not constitutionally protected under the Fourth Amendment, and I gave specific examples. And then we talked about reasonable suspicion, and I think we've covered that just about as much as we're going to. We'll revisit it again in one of these upcoming videos shortly. But I want to move from reasonable suspicion, which is one of the lower, if not the lowest, standard of proof that we have in the legal field, to probable cause, which is a step up from reasonable suspicion. It's a higher standard that police officers and judges have to find in order to do certain things. So first off, I just wanted to give a basic definition of what probable cause is. So probable cause is evidence that would lead a reasonably prudent person to believe that a crime was being committed and that the suspect, the defendant, was the one who committed the crime. And probable cause is required for a number of different things in criminal law. It's required for searches, it's required to obtain a warrant from a judge, it's required for arrests, and it's a standard that judges use at preliminary hearings in felony cases or at a 991 motion in a misdemeanor case. Procedurally, we can talk about some of those things later, but the main point that I want to get across here is that probable cause is very important in criminal law, and it's a standard that has to be met at multiple different points. One of the first things that I wanted to mention about probable cause is that, like reasonable suspicion, it's a totality of the circumstances test. So when a police officer is looking at whether or not there is probable cause, they're going to look at everything. They're going to look at all the facts, or at least they're supposed to look at all the facts, and the courts try to look at all the facts as to whether or not probable cause existed. But the courts want this to be an objective standard, and it's kind of an interesting little dance that the courts do, right? Because a police officer has to subjectively make the probable cause determination. A court has to subjectively make the probable cause determination. But the appellate courts and the Supreme Court is trying to create some kind of a standard, and they say that it's objective, and there's debates back and forth whether it's objective or subjective, but as far as the courts are concerned, it's objective. And so they're looking at all the totality of the circumstances and seeing whether an objectively reasonable police officer would have found probable cause in a certain situation. But what this means is that if there's a pretext for the stop, or if the purpose for the stop is coming from a bad place, or maybe is unlawful, but there's still probable cause, if you look at the totality of the circumstances, then an officer might get away with some kind of an abuse. So for example, you might have a racist police officer, and maybe they see a car full of young black men, and the police officer follows them and then pulls them over. And in that situation, the police officer would have just pulled them over because there's 4 black men in a car and the police officer's racist. But let's say that same facts, except for the car that the 4 black men are in doesn't stop at a stoplight, turns right at a stoplight without stopping. The officer's still pulling them over because it's a racist police officer, but the court might say in that situation, well, there's probable cause. So it doesn't matter that the police officer is racist. In that respect, there was probable cause, and an objectively reasonable officer would have found that there was probable cause in that situation as well. So that's kind of a frustrating thing about probable cause, and even reasonable suspicion too, that it's an objective standard. So some of these subjective beliefs and subjective actions on the parts of the police officers aren't necessarily what's going to sway the court one way or the other as to whether or not there is probable cause. There's other ways that an attorney can attack whether or not a police officer is racist, and that might involve a Pitchess motion, getting access to the police officer's disciplinary records, things like that. But as far as the probable cause determination, The judge and the police officers are supposed to be really looking at the totality of the circumstances. So that's kind of the basic rundown that I wanted to provide for probable cause at this point. We'll do a couple more videos on probable cause. It is a very important standard that we have in criminal law, and I think it's one that we need to take a little bit of time to explore. But thanks for joining me today. I hope you'll join me next time when we dive a little bit deeper.